Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
The video,
Explain it to us. We're listening.
I just did. Like, we were playing, and then, like, I thought it was... My plan was not to go upstairs and go to sleep. My plan was not to... He'll be up here anyway.
But you willingly went upstairs and went to sleep. No one forced you to go upstairs. And
My plan wasn't also to leave him in the suitcase. Because I went upstairs, and then I fell asleep.
But why didn't you consciously think he's asking to come out?
I didn't do it intentionally.
Good morning. Welcome to the Court of Public Opinion. I am the recovery addict. Thank you very much for being here. It's I think I'm late. I think I'm just a little bit late. And it's possibly because it was a late night last night. Let's see. A couple of you are not happy about how I treated the investigator last night on the video stream. Barbara Farthing, let me just read this. Just watched the video I already did about Sarah Boone letter and prison break. Man, that was rough. The laughing at the investigator really bothered me. Kind of mean-spirited. If this were like an individual, I would. I don't know. I was talking to Mrs. Ari about this very thing, and she said that video you did last night was not you. Is what she's told me. She wasn't a big Mrs. Ari didn't not like my video either. So here's what I'll say. Yes, it was late night. That's no excuse. I probably was a little too rough on the investigator. I don't know. I've got to do some thinking, maybe some soul searching on this one. I did want to definitely look at a couple things. Yes, he did steal the logo from the TV show. He does base his business out of a shared workspace that also has like a commercial kitchen and a conference center and things like that. So it seems like he was maybe bragging a little bit bigger than he was bigger than his bootstraps type thing, as far as his claims about his company. He did spell the client's name wrong in the letter. There's a lot of things that I find fault with. That being said, I don't know. He may be an amazing guy. I think there's even a building named after him when he retired, which I've heard was after his DUI charge. That they named a building after him, and he had rave reviews as a police officer. So anyway, that being said, I do want to, let's see. I don't think Billy's a real investigator on his Facebook. People can meet with him and choose lunch whenever they want, wherever they want. He seems to be more of a, I don't know. This is the sort of page I would expect from like an Elvis impersonator. That's what I'm seeing. Somebody who wants to look the part. Chat on screen, that would help. Sorry about that. That means I need to first go way back up here and say Kim R. I think it was Kim R. One chat today. Again, repeat offender. You know what to do, Kim. Congratulations on being first in chat. Everything IP related worldwide is now yours to take care of. Not yours to like sell and make money off of, but just yours to repair and keep running. Thank you, Kim, for being first in chat for that. All right, couple things. I wanted to talk about a few things. First of all, we're still waiting on a jury. I feel short today. Got a lot of headspace. All right, I wanted to talk about the fact that first of all that Thomas Randolph jury is not yet been selected. We're still waiting for that to be done. Flobby Jobby, welcome to the gallery. Thank you very much for your support with the green courthouse there. Appreciate you very much. Thank you for being here. With no jury, the trial can't start. We need a jury there. We need those 12 men and women to be sitting in that box and 2 alternates before we can hear opening statements. So we're in a holding pattern with this trial until that happens. It's going to happen sooner or later. If they can't seat a jury, they might be looking at change of venue, and I don't think that's going to occur. That hasn't been pushed for. Excuse me. But that being said, I want to go back and talk about Sarah Boone, because although we have a lot of fun reading letters about Sarah Boone, she raises some serious issues that I, like deep down at a soul deep level, have a problem with. Particularly, it's the fact that she is sitting in jail for now, 4 years, almost 4 years, that she's been in jail. And according to her, she's never waived her right to a speedy trial. And she hasn't agreed to half the stuff her lawyers have filed on her behalf. And she's not seen her lawyer. She's not getting representation, and her case is not moving forward. We know it's moving forward, but she doesn't think it's moving forward. So take out the fact that she's admitted to the crime, okay, admitted to doing the acts that caused George's death. Take out the fact that she filmed it and mocked him and everything else, and that she really showed a dark part of herself on that video. Take out the whole crime and just say, if I were in that situation, accused of whatever the crime was, it doesn't matter the crime, would it be right? Would it be right to have to be held in jail for 4 years waiting for trial, and basically have no communication with an attorney, or very, very limited communication with an attorney? Now, I've looked at some of the other attorneys who have commented on this, and who've looked at the dates that she's presented, the time frames, the stamps, and said, it's not optimum, but it's not that bad. It's not, it's a case that, usually there isn't going to be a lot of communication on. There isn't going to be a lot to go into. So I'm not sure. It's, I will say this. I think Sarah Boone right now, if I were the one voting, will have won an appeal for ineffective representation. No matter, obviously, if she's convicted, that she has an appeal in the bag. It's like having a get out of jail free card right now, that she gets a redo because of this. And arguably, she might be to the point where she might get something at a higher level. And what I'm saying is, if she really never waived her right to a speedy trial, and she appeals this thing all the way up to the Supreme Court, either the state or wherever it's going to go, she may be let off because her rights were violated, and that they basically lose the chance to prosecute her. That's what I'm thinking. So yes, it's funny to talk about how, to look at her and say, how can you see this as intentional when you intentionally did it and then you walked away and you filmed it? The irony there is quite strong. But on the other side, the facts of this case that are troublesome, very troublesome, are the rights that seem to be not honored, that they're being violated. Let's see here. Because of how difficult SB is, I wonder if her trial could be switched to a bench trial instead of a jury trial. Just wondered. She is out of control. I see it differently. Yes, she's a difficult client. She's a demanding client. There are others. I'm pretty sure Thomas Randolph is a very demanding client. You guys watch the Dateline specials on the Discord watch party. One of his attorneys, the one who was the attorney for OJ, who actually dropped the case, basically said he was the one sitting there in cuffs in a jail jumpsuit, and he acted like he was running the show. And so it's
Scott, go Google flobby jobby meaning, please.
Ella. I'm not sure if I can. Hang on one second. Hang on. Ella, I'm trusting you, but if you lead me astray here. I Googled Ella. Oops, that's not right. I can't Google anything that has the letter B in it because my keyboard doesn't work. It says, did you mean Hobby Lobby? You're talking about the TikTok account? My Google is not returning possibly what you wanted me to find there, Hella. I'll have to look into that a little further. No, don't Google. It's just cringe. Well, I Googled, but it brought up a TikTok account. Maybe I've got like safe settings turned on or something. That word is poop. Saved by Google. Okay. Let's see. We have we have a few things to talk about. I don't know. I want your take on things. Honestly, I watched some of the video we did last night, and yes, I was tired. That's no excuse though. But I've never been quite as snarky as I was on the video last night, and it's not something I'm proud of right now. But I'm not sure if I'm, I'm not sure if it was right or not. I don't know. I need your input. Help me think this one through. All right. I wanted to go over the letter one more time in a more serious way. Let me pull it up here. The serious part of this letter would be anytime her rights are violated, and I realize it's humorous to look at the way she's counting the dates and everything, but the fact is she is counting. Someone should be counting. The court should be counting and say, hey, it's been XYZ days until since she's been arrested, and she still has not had her day in court. That's a bit of a problem for me. So let's see. She gets this letter from her investigator. I've told you I don't think that's actually her investigator. I think she probably reached out to the investigator, and he said, "Let me look into it and see if we can do anything." And the response she got is the letter that she posted here. No, I'm not in the doghouse. I'm trying to figure out what's making that noise. Are you hearing that noise? Grr. Okay. It's bugging me just a little bit. Anyway, you're snarky, but it was fine. Sometimes you need to be silly and laugh. I'm not in the doghouse with Mrs. R.A. I very much value her opinion because she has a better read on things than I do. Matthew Harris drops his video today. Please consider checking it out. We're looking forward to that. I honestly feel bad that her resources that she's entitled to are not working with her. Rebecca, I agree. We've looked at Frank J. Bankowitz, before. He has been reprimanded previously for not communicating with clients. And it appears that I wouldn't say he's not communicating with her, but very, very seldom. But I'm not sure if it's enough to be a violation. The judge says, I see the included letters I've got from my investigator communicating with me to provide an update on why we have not been able to meet since our last uneventful meeting with my attorney, Frank Bankowitz. So that's why she has not been able to meet with her investigator since she last met with Frank Bankowitz on May 18th. My investigator, and that May 18th, I believe that was an ordered visit. The court ordered Frank Bankowitz to meet with Sarah Boone by that date. My investigator also has not been able to make contact in attempts to move forward and produce very much needed overdue progress in my case. I, as Mr. Bankowitz's client, cannot communicate with him via phone. This is an issue she's raised from the get-go. Basically, Frank gave her 2 phone numbers, and apparently they're burner phones that have no money on them, or they have no service. But the numbers have not been activated, or she's not able to get them, or the numbers are wrong or something, but she's not able to connect. And she has 2 numbers that she continuously tries and is not able to reach. She keeps asking why they're not working, and he has other excuses. It's been going on for 13 months. Now, she keeps asking why they're not working, and she says that to him. So there has to be times that she's able to meet him and say, why are your phone numbers not working? So it's not that he's completely ghosting her. It's that she's not getting the contact and availability that she wants out of Mr. Bankowitz. By not activating, he's actively hindering progress, compiling even greater amounts of carryover, and in the meantime, information for review when or / if we do eventually meet in person. That part, he's not adding to the caseload as far as things to discuss. It's just meaning that as she finds more information or has more questions and she's not able to address them, that the question pile is building up. So last time to date was 77 days, prior to that 99 days, and 147 days prior to that. So it's been a good break. You know, this quarterly or 3 times a year schedule that the attorney's been holding with meeting her is a little sparse. It's a little sparse. KQD says, is there a way to find out whether her speedy trial rights are being violated? What actually constitutes a violation? Is it a state issue or a federal issue? Here's what we'll look at, and this bugs me because there are some trials that are or some states that do very poorly at this. So, the Supreme Court held in 1967 that the right to a speedy trial is one of those fundamental liberties that the Due Process Clause of the 14th Amendment makes applicable to the states. So this is a right enshrined in the Constitution, according to the Supreme Court, and everyone gets it. This is not like, oh, you've been arrested, so you don't get that. No, this is specifically for people who have been arrested. I saw the spelling mistake as well, Vivian. Let's see. The 4 factors for a speedy trial are the length of delay, the reasons for the delay, the appellate's demand for a speedy trial, and prejudice to the appellant. So length of delay, how long it's been waiting, why it's been waiting. So, for instance, during COVID, there were some states that the time that went between when you're arrested and when you go to trial, if you want a speedy trial, it was lengthened. And they said there's nothing we can do because of these situations, because of this pandemic, because of the ordered situation. You know, the way we have to hold court now is not as effective. It's not as efficient as it was previously, and we just can't get it done that fast. It's not that we're delaying; it's out of our control. So that would be a reason that would be in favor of the court, as saying this delay is not a violation of your speedy trial. Sarah Boone obviously was in custody for the duration of that pandemic, but I don't think that would apply now. So I don't think the court would be able to say that's the reason why. The length of the delay coming up on 4 years, that's a long, long time. The appellant's demand for a speedy trial. Now, on paper, Sarah Boone has said that, or at least through her attorney, has said that she's waiving her right to a speedy trial. And unfortunately, that basically, it turns the timer off. There is nobody that's like, well, you waived a speedy trial, but, you still should get it within X numbers of days. The judge says, look, this has been on a long time. I'd like this to move forward. We've pushed this out already. We're coming up on 4 years. We need to make progress on this. And that's the judge. I'm hearing the same sound. Hang on one second. Let's see. We have... Did I fix it? I think I fixed it. I think I had a loose connection. Is the sound better, Erica? I guess you're going to keep this going as long as she can. Kelly, I don't think she wants to keep it going. She honestly, and she said this, and I believe her, okay? I believe Sarah Boone in this. She honestly wants progress. She wants to have her day in court. She wants to be able to speak and be heard, and she thinks that will be effective in convincing people to agree with her. I don't agree with her there. I think that as soon as she tells her side of the story, people are going to look at her and shake her head and say, girl, you're crazy. But she wants her day. Anyway, she says the investigator needs to meet with her, and it's been a long time. He can't meet with her because, let's see. Let's see. We're going back. With the aforementioned being said, Judge, would you please be gracious enough to communicate with Mr. Bankowitz to supply the requested simple information my investigator needs, considering the number of days or weeks in between our meetings with him. Okay, what she's doing right here was effective in a previous letter. She wrote to the judge and said, "Judge, I can't hear my lawyer. I can't see my lawyer. Can you please tell him to meet with me?" She said that once before. And what happened, we didn't have the judge actually like, "Hey, Mr. Bankiewicz, I got a message from Sarah Boone for you." But he did in the next hearing say, "Look, your client's writing me letters saying he wants to meet with you, saying you're not available. Meet with her." So that may happen. Let's see. May was the last one. May, June, July, August. It's quarterly. It's about due according to the previous schedule for a meeting. But you'd think there would be more meetings as we're getting right up to the court date, as it's coming soon. Let's see. My innumerable attempts have been completely unsuccessful in any form of communication, Mr. Bankiewicz, via phone, letters, email, and voicemails attempted by an outside source. And now we can add text messages to that because of her investigator. What else can I do, Your Honor? It seems my only hope is for a court date, which I am included in, where my attorneys, and she says that meaning that's a jab to the fact that she wants to be at all of her court hearings, and there are some that have taken place where her presence was waived by her attorney. And so that's where she's jabbing at. She says, "I didn't waive my presence at any of them." Where my attorney's attendance is mandatory and I can vie for his attention during the minute minutes beforehand while in the courtroom. So literally she's like, when I get hauled in and I'm sitting in the courtroom, I can be like, "Hey, attorney, over here, we need to talk." She's like, that's the one time that I think I'll be able to talk to him, where we're in the same room, where he has to be there and I get to be there. I can get his attention. And then we're going to have to talk. Well, the cameras are on us, and she has a concern there. If the cameras are on, we should not be watching the communication that goes on between a defendant and his or her attorney. Those should be protected communications, right? So the news cameras should not be pointed at her, so we can read lips and everything else. Cachette just gifted a membership. Thank you very much, Cachette. Appreciate your work on the shorts and the videos last night as well. You're awesome. So she says, "I'm sure all the allowed live cameras would provide footage of me doing so every time. I don't want to waste any more time and catch up in the courtroom is unfair and ridiculous. When can we have a real meeting?" She's right. It is not fair that her meeting, face-to-face time with her attorney, is filmed live on camera, and that's the only time she can do it. That's not fair to her. It is ridiculous, and she does want a real meeting. Now, just because she wants to meet in person does not mean she gets to meet in person. She can't like dictate this and say, "I want a real meeting. I want you to bring this. I want you to bring this. I want you to do this, and the other." We've talked about this before, but the attorney is the one who tries the case. The attorney is the one who chooses what theory of defense he's going to use. She doesn't get to say, "No, I'd like you to actually say that this happened," or "I'd like you to take this approach." The attorney looks at all the evidence, looks at all the the exculpatory evidence they can put together, the evidence, from expert witnesses, any factors that might come in that might be mitigating factors, and they put together their own theory and present it the way they want. And it may not be at all what Sarah wants to have told about her story. But she doesn't get to make that call. She gets to decide what her plea is, but she really has to work with her attorney, and hopefully with and not against, in finding what the defense is. Just wondering how long they can make a person stay in jail with something like this. Dodie, I don't think there's a date. I think individual states have standards where you have to be indicted by a certain time. You have to have a court date by some once they have like a timeline they've built to say this is our standard. But I think it'll have to go to the Supreme Court to have them rule on something and say this isn't right, for some of those standards to be challenged and say you need to do it faster. You need to have a court happening sooner than this. Let's see. This is letter number 10. I'm fascinated. We have hours of footage of someone lying, but every time they write a letter, people take it as the truth. Kai, are you talking about this letter? Are you saying that you don't believe what's happening in the letter? Because the lawyer, Mr. Bankiewicz, has confirmed basically in discussions with the judge some of the facts that Sarah has presented. And he's given reasons and excuses for why he hasn't been able to meet and things like that. So I don't think the letter, the dates, the amount of time that's carried on, the time frames for how long they've met. I think she's got like timestamps on that. Those are things that can be checked by jail records. I don't think that she's fibbing. I do think she's stretching the truth when she says that she has this private investigator that she's working with. Christy, congratulations on 6 months. You got that yellow courthouse. Thank you very much, Christy, for your support. I love the pooch with the Batman outfit as well. Wonder if she ever thought about representing herself. She's certainly not short of confidence. Gordon, she has. She approached it briefly, where she said, I may be better off by myself than with this. I think she knows that she doesn't know the legal system, right? She's not dumb. I mean, she's done some things that we look at and say that was stupid, but Sarah herself was a great student in school, so she's able to learn. She's able to understand the system of how grades and assignments work and do well in that environment. So I think she's smart enough to know that she is not in her environment in the courtroom. Right? This is not her comfortable place where she knows what's going to happen next. As a matter of fact, she's very confused and she's very distraught about not knowing how this process works. She's not an attorney. She doesn't know what's going to happen next. And she's expressed that a lot. She's like, I want to move forward, but I can't, and I don't know what to do next. Unless my attorney talks to me, I can't. Eddie, she does have legit concerns. And like I've said, I think she has a get out of jail free card in an appeal in the bag with this. Let's see. Who is paying the private investigator? VC, I would be very, very surprised if he has been paid anything at all. The letter that we saw sent back, and we'll get to that here in the letter in just a little bit. It's just down one more page here. The letter we saw looks like a response that a business might give as you're in negotiations to do business. Where they said we're looking into seeing if we're going to be a good fit as a customer client, or as a service provider and a client. See, we watch traffic court hearings where the accused get more time with an attorney in a breakout room for driving without a license. Eddie, this is true. This is true. Now, I will say in those cases, that might be the first time they see their attorney is the day they show up in court. And we also watch those little court hearings where it seems pretty clear, even in Judge Cedric's courtroom, that the attorney has never met with anybody or even opened the file, and they just it's this type of case, we're going to do this. It seems there's very little communication in some cases. Do we really want her out of jail, Holly? It's not that we want her out of jail. It's I personally, myself, having watched her the police body cam video as well as the interview video that we watched together, I feel she's guilty. She's told us she's guilty. The facts that we've heard so far from the police of what they've gathered indicate that she's guilty. It's not that I want her out of jail, but it's wrong to hold somebody the way they're doing it. And this gets into a little gray area. Well, it's not gray. It's a moral issue, where suddenly if we are okay in holding somebody without actually taking them to court, we collectively are giving up a right. We all are giving up their right for ourselves and for each other. And nobody should lose that right. She has the right to have her day in court before she's just held indefinitely. And 4 years is a long time. I mean, by any stretch of the imagination, 4 years is a long time to not go to court. Do Matthew and Nicole think she has a get out of jail free card? I would reckon that both of them think that she does not. Because you've got on file, you've got a record that says that she's waived her right to a speedy trial, which the court views as authentic. But there are some missing documents, according to Sarah. Some of the paperwork from even her first attorneys never made it through the chain of attorneys as this has gone along. And so they may not have any evidence that she ever did waive her right to a speedy trial, and that could be an issue. Good morning, Ted. But that would not be an issue for this court to decide. That would be an issue for an appellate court to decide, in my opinion. If Matthew and Nicole are on here, I know both of them are pretty busy, but if they're on, I'd love to have their feedback. Let's see. but people are being held in jail without trial for years in every state. And this is a problem. And I have a problem with this happening in every state. Look at Judge, Manning. We can't watch Judge Manning on this channel. She's not happy about that, about us or anybody else showing her videos. But if you watch Judge Manning, you've got hundreds of days without an indictment. And it seems very common how long people have sat there without an indictment. It's like, hey, they've been in over a year without an indictment, and it's like, are you serious? How long are we just going to hold people because they can't get away, so we can get away with it? I'm swamped in applications at the moment. Hopefully you find a good one in there. If she's actually guilty, what's the difference? The difference is she's not been found guilty, and that's where the rights come in. Once she is adjudicated as guilty, then from a legal standpoint, they can punish her. She can get life in prison without parole, because that's the maximum on the case, because it's a second-degree murder trial. But if she's not guilty, you hear, all suspects are innocent unless proven guilty. Well, you hear until, but if you are innocent, can they hold you in jail? So we have to view her as an innocent person, because right now she is innocent unless proven guilty, even though she's admitted to it. Let's see. Somebody's calling in. I don't know who it is. Let's take a gamble here.
Call from
Bree.
Bree, how are you doing this morning?
Good. How are you?
I didn't get enough sleep, but you guys know that I was up too late last night.
I know. Hey, really quick, I just wanted to say something about last night. Mm-hmm. I don't feel, in all honesty, we were really making fun of him, or if that's where it was going. I think what it really was the intention of, we knew another letter was coming. It's there. We know this. Mm-hmm. But I think we were shocked at what the letter was. And then it had these ties to the Prison Break logo. And then instead of having like a typical professional headshot like you would think an investigator had, he had these kind of judgy pictures, almost like glamour shots or something, not what we expected. And I think that caught us off guard, and that's where we laughed, not specifically laughing at him. I think just the kind of the shock is just kind of what turned on the giggle factor, not as something negative as to make fun of somebody.
Yeah, I've said a couple times, and thank you, Bree, for saying that. I did say several times, I don't know, he may be the best guy in the world. He needs some help with his company name, his logo, and his website. Mm-hmm. That might be, that might be it. He might be the best investigator anyone could possibly have. But for him to present this way, it was just, it looks like a joke. I mean, honestly, if someone was pulling a prank, it would look like this.
It would, yes, 100%. So I saw some of the comments, and people being upset, and I can understand, going back and looking at it, kind of where they could see that. But from somebody who was there in the moment yesterday, I just really want to let you know, I don't feel like any of us meant it that way. It was meant because, like I said, I think we were just so shocked. We went to the website and we're just like, this is really what we're seeing. In that moment, the shock factor set in versus this is real life type of thing. So. Yeah.
Bree, thank you very much.
I just wanted to kind of...
I appreciate that. It was a lot of fun. I think in the future I need to do it with a little more sleep instead of late at night. But thank you very much. All right.
You're welcome. We'll talk to you guys later.
We'll see you, Bree.
Bye, group.
Bye. All right. Can you read part... Keshet says, can you read the part where he said he sent one email and 2 texts to investigate? That's right here. And this is the letter that she's attached to the judge. And I think the judge is going to accept this at face value, really. The judge is not the trier of the facts so much as the trier of the law. So he's looking at information, and this looks like it looks like somebody who is actually licensed to investigate crimes in Florida. Okay. And, the fact that he has a funny name about breaking out of prison, or that he's stolen the logo from a popular TV series, that doesn't play in for the judge at all. So the judge is looking at this, and the judge is saying, hey, we have this person who is trying to meet with the lawyer and can't. The judge isn't concerned about prison break investigations not being able to meet with Mr. Bankwitz. Zero concern. That's actually not his problem at all. All this is one more evidence that Sarah Boone has in her arsenal when she says, I can't meet with my lawyer. How can I get a legitimate defense or provide for my own defense or provide a defense if my lawyer won't call me? And this is just one more person saying, hey, look, I work in this system and I can't meet with him either. Something's wrong. So the letter itself is sort of humorous in that he's basically got a letter from Sarah, responds, he says multiple times to contact your attorney since meeting, but unfortunately I've been unsuccessful. I'm not sure what's causing the issue. And then he documents what he's done. He said on May 22nd, I sent him an email requesting him to contact the jail so I can have access to visit you and proceed with the mitigation process in person. Additionally, I sent 2 text messages to his phone June 1st. So basically a little over a week later, he sent 2 text messages, and then a week after that. So he's got like 3 attempts over 3 weeks, but received no response. And so he's like, hands up in the air, look, I'm only an investigator. There's only so much I can do to find somebody. And apparently email and text messages I'm done. He's like, I'm done. So unless I hear from him, my hands are tied. So that part was funny. The signature was very fancy. And I love a good John Hancock. I really do. The signatures are great. But it just seemed... It seemed with everything else to just be a little too much and almost for show. Then you get the pictures and everything else. So I'm hoping that that Mr. Billy Lane is an amazing investigator. I'd love to see Sarah have whatever. I mean, if she thinks that she needs a mitigation specialist to come in and can do good for her and it would serve her well in this defense, I hope she gets it. I really do. I'm not sure if Billy Lane is the guy, but yeah. Anyway, let's see. A little flamboyant for the signature, and that's all right. A real investigator would show up at the attorney's office. Jamie, the part that struck me was the contrast between what we saw in the letter, and I realize he probably has not been paid yet, so he has no duty to perform any investigative work at all without being paid. So if he has not been paid, I don't blame him at all. But the contrast to what he presents in the letter, like, hey, I tried, and what he presents in his bio as, look at what I've done. I've these with out-of-state investigations and trailing people for weeks, and hidden cameras and everything from cyber stalking, all the way through. It just seems like his shrug, like, oh well, came pretty easy. We don't go along with her truth. What is her truth? I'm not a big fan of people saying her truth. We heard that in the her or his truth. We heard that in the that was in the Skeet case with Gwyneth Paltrow. There was a witness that was confronted with statements that seemed blatantly false, and they were bringing it in from another witness, her sister, and they were saying she would say this, and I'm like, well, that's her truth. That's how she sees it, type thing. I'm like, well, really, I think when it comes to facts, there has to be something that can be measured and quantified and counted and displayed and basically judged. You can't just say, well, it's true for me and it's false. Well, you're guilty as my innocent, type thing. That's just how I see it. You can't have it both ways. Kathleen says, where are the battered women advocates? In this case, Kathleen, Sarah Boone did have some situations that were awful as far as domestic abuse goes. From the court evidence, we know that she was both on the receiving and the giving end of that, according to the paperwork, and they've both been in jail at different times because of this. So their relationship was not a good one by any means. The thing that's going to come back and bite Sarah in this particular case is that she, by her own admission, says that wasn't happening, that they were good, that was in the past, and that was not a thing anymore. Maybe he could only do what she could afford to do. Yeah, your 50 cents will only get you so far, Becky Lou. Maybe Billy Lane provided everything that he was supposed to under the payment he had received. VC, I'm looking more and more like we're not going to Las Vegas. which is good. But we want to look at some other trials to go to. Obviously, we're still looking at BK, Corey Richins. Whenever that one comes down, we've got some things in the works. Does anyone think she's a danger to the public? I don't think, Thomas Randolph is a danger to the public. I think we've got somebody who's actively gone out and solicited, according to police, hitmen to eliminate people he sees as a problem in his life. That's a danger. Sarah Boone doesn't show any evidence of that, although she's had some problems in her own relationships. I don't think that she would be a huge danger. Hide and Seek Investigations would be a better name. At least it's not the name of a movie. Oh, maybe it is. Hide and Seek, is it a movie? The video is a smoking gun. Is there any chance that that a good defense could throw it out by a miracle? Cachette, no. There's no way. There's no way. This was, okay, and let me tell you why. The evidence was collected by, she gave permission. She says, go through my phone. I've got the videos, watch them. She literally gave them permission. So this isn't like a search warrant or they searched her phone without permission. She literally said, go through, check out these videos I've made that will tell you everything. They'll explain everything. And they did. I'm like, oh, you're right. They're here. And they do explain everything. So she doesn't have the ability to say, you didn't have permission, you didn't have a warrant, you didn't have probable cause, whatever it was. So there's no way you can throw it out. She's verified that she's the only one that had access to the phone, that it had to be unlocked by her, that George, when he did use the phone, had to get her permission to do it. And we know it wasn't George. She says she's the only one in the house at the time when the video was taken. It's just they've nailed that down so carefully. It is a smoking gun, and I don't think they can poke any holes in it. The best she could do is try to say we were acting, we were pretending. That's how we flirt. That's and the average jury member is going to look at that and say that doesn't sound like flirting. Immediate or specific danger, but still a danger. We'll be following the Caitlin Armstrong case out of Texas. I remember them by other names instead of by the client name. So hang on one second. Or by the defendant name. Let me take a peek at this one. Caitlin Armstrong. It's been pushed back. So she killed the bicyclist. Here's what I'll tell you. The Texas is very hard to follow cases out of. We've tried. If a different county runs things a little differently, possibly. But let's see, what county is she in? She's in Austin. Or is that where it happened? Travis County. Okay. Travis County Jail in Austin, Texas, with a $3.5 million bond. That's October 30th. I'll look at it, but I'm not hopeful. I'm thinking that there's a good chance that Texas will not allow video of this one. Court TV will be covering it. A lot of times some of the big channels say they're going to cover it and then try and then end up not covering it. So we'll see, because Texas has been a stick in the mud that way. Rona, we don't know how he got in the suitcase. Only Sarah knows, and George isn't with us. Frank Banquet says reviews on lawyer ratings and has a 1.1 rating. Reviews mention he doesn't call back and doesn't file things. Yeah, that's he also has some reprimands on the official record for that as well. Dodie says, I found her lawyer. Should I try to call him? No, it won't do any good, and he can't talk to you about it. And basically, you're just taking time that he could possibly be taking her call. So I wouldn't want you to interfere there. George is sure being lost in all this from what I'm seeing. Team George here. Purple Haze, yes, there should be justice for the victim as well. And honestly, the right to a speedy trial should be for the family as well. This gets stretched out for them, right? From the day the arrest is made until, the day the sentence is imposed and a little bit beyond with appeals. The family is going through a terrible process that just can't go away, that is just kept alive in their life. And most of them wish it would end. So having a speedy trial is helpful for them as well. And I think it would be appropriate. I think they should push for a speedy trial. What happened to Judge Boyd's jury trial? That was a crazy one. She's had some doozies of cases involving SA, and that was one of them. Sent a link to Albuquerque court. They do Zoom court, and so they might be fun to watch. Sent to the burner phone. Brianne, did you just barely send that today? Let's see. I've heard people say Billy Lane Choppers is the same person as the Billy Lane investigations. I haven't seen the picture that matches those two up, but if it is, he's spreading himself quite thin between two very big businesses. Let's see. Let's see, Brianne, if you sent the link to the burner phone, can you send me another quick message just with your name on it so it puts it up on the top so I can find it? Because I've got about 700 messages on there right now. 6-Volt Bus says, happy to see this community thriving. Welcome to all the new members. Thank you very much, 6-Volt. 7 months. 7 months. And an amazing mod on the channel as well. Let's see, I'm waiting. Brianne, I'll keep an eye on that. I think if it's the list that I saw before, there was a list of courts, and there was a ton of them, a ton of courts that are all aired on Zoom. But they have a strict thing at the very top that says none of these can be rebroadcast at all. Tony Green just got on. Was the jury selection for the Randolph trial completed yet? It has not been completed to our knowledge. We haven't seen any indicator of that. I might call the producer there on scene from NBC Studios and see where we're at. It was interesting that when the interrogators told her about the video before playing it, she claimed no memory of it, yet tried to evade them playing it. That is telling. I believe that she had no memory of it. There's no way that she remembered filming that and then also told people so many times leading up, before they even said they had this video, to check out the phone because I have all these pictures documenting things. Public defenders are all overworked. There's no telling how many clients they have at a time. Thomas says, you no doubt have disclosed this, but we only have Sarah's interpretation of her lawyer. We can't assume he's actually doing these things because she's known as exaggerator of the truth. Yes, but we also have some confirmation. The judge confronted the lawyer earlier in the year about not meeting with him, and we also know that the lawyer has previously, we know him as someone who doesn't meet with his clients very often. So there's a lot of truth on both sides there to how this is going. Brandy looks so much better today. That is awesome. I'm glad she's feeling better. Okay, 3 months and 15 days until I get my yellow courthouse. I'm sure the time will fly by. Nancy, it will, but we'll have a lot of fun between now and then. We don't have this issue in Canada. It's always a quick trial, but we have only about 45 million people, so no comparison to the amount of crimes committed between both countries. Definitely the population is a factor, but I think if we have too many people committing crimes and not enough judges, we need to get more judges, right? We need to expand the system instead of just saying, well, we have one judge in this town and he's busy. We need to expand the system to match the needs of the community. And those needs in the community include the need to have a speedy trial for people who are accused. The funniest thing about the Sarah Boone interview is how she swore off alcohol a few times during it, after saying that she was not drunk at all and that she likes to have her wits about her. I'm behind. I heard by her own admission they were good, but in the video she talks about the abuse. That's what I feel when you choke me. It's a good point, PFOG. She does bring up, and the video you're talking about, in the video she filmed him in, she says, this is because, this is, she's saying, this is how I feel when you treat me in a specific way. Did you see the police standoff stolen vehicle shootout event when you signed off last night? It was crazy. 3 Bearcats surrounding one guy. I did not, kitty kitty bang bang. It was late. I heard there was a police chase, but I was spent. That's correct. I believe she was blacked out and wonder if Ambien was involved. Was there any evidence that there were any drugs in the house? Prescription or otherwise? I thought it was just wine. Aztec says, what is your burner phone number? If you type burner, like Kimar did in chat, it goes ahead and posts the burner number on the screen, and there it is. That's the burner. Okay. Okay, Brienne. Let's see. You sent me these courts. The Metro New Mexico courts. They have a disclaimer saying recording or live stream of hearings is prohibited. Violation may constitute contempt of court and result in a fine of up to $500 and a jail term of up to 180 days. So they're not big fans of us using their stuff there, unfortunately. They're in New Mexico. Also, most of Europe is way more efficient than trials. They take care of business. Kelly, I'd be interested to see, just from a statistic, like percentages-wise, what the conviction rate is in, say, like Canada and Europe compared to the United States on the same level of offenses. Because if you don't have, if you don't have 3 years to put together your case in a murder trial, you basically are rushing through things, and you're probably going to miss things. Imagine if the Brian Koberger trial actually starts this fall. There is so much evidence, literally, that if the prosecution will go in there having never looked at some of this evidence, having never even reviewed anything. They're like, we haven't even had time to look at this camera. We haven't done anything. There's so much to do to prepare for a case like that it's difficult. She basically told George she was getting revenge on him. I realized that, and had there been abuse at the moment, she would be in a different situation. Possibly still not free and clear. But the fact that she says everything was fine, there's no marks on her. There's no indication that in the, very recently there has been anything. If I remember right, she and George had 2 bottles of wine between them, so it's reasonable to believe she didn't remember taking the videos. Yeah, I don't think she remembered the bottles of wine even. Red Pen says, I sent you a package yesterday, should be arriving Saturday or Monday. I will watch for that, Red Pen. I'll head down to the post office and keep an eye on it. You guys were hanging out way past my bedtime. I'll catch up with that video later. Purple Haze, I'll never drink again. Like she expected investigators were going to say, if you promise us, you're free to go. So many times, the nevertheless moment. She says, this is punishment enough. Me having to live without George is punishment enough. I shouldn't have to face anything else. This is bad enough. The investigators didn't buy into that at all. 0. Let's see. We don't know what happened before those videos, though. For all we know, there may have been evidence of him doing something. There could be, but they took pictures of her body to see if there was any injuries afterwards, and there was none. So there was no bruising, there were no cuts, there were no scratches, there were no black eyes, there was nothing apparent on her that would show that something might have happened leading up to that. Why would they set the BK trial for October? Jenny, in that case, BK is saying, I want a speedy trial. My little one is being a siren in the hallway. He's just making fun noises. The BK is saying, I have a right to a speedy trial, and I'm not waiving that. And so, because I think in their case, they're like, it's got to be X number of days, right? Idaho has a benchmark saying speedy trial happens right here. And it's different for every state, but they're saying this is where it wants to be, or this is where we have to, this is our objective, this is our finish line. We have to be ready by then. So they've set the trial date, according to the request of BK's lawyers, as far out as they can be, but still be within that speedy trial period, because they don't have enough time either. And they've raised that as a concern. They're like, we want a speedy trial, but we want as much time as possible. I mean, we're not ready today. We want as much time as possible to prepare for that speedy trial. And they may eventually just say, we waive that right. We need more time. Steal your heart. Look at that. Yellow Courthouse, 7 months. 7 months as a supporter. Appreciate you very much. I think your name has changed. During those 7 months. Appreciate you. I thought Sarah Boone said she passed out that night because they had been drinking. In my opinion, she sounded drunk when she made the 911 call. Rona, she definitely sounded like her words were slurred when she filmed George in the suitcase. So that would indicate that there would be some drinking involved. It would be supported by the fact that she woke up very late the next morning, possibly due to a hangover or late drinking. And then I'm not sure of the 911 call. Not sure about that part. I don't think she was drunk when the police were talking to her at the scene. Alicia, look at that blue courthouse. You're on your way. I thank you very much for being a supporter. Welcome to the gallery. This is month 2. Yay. Thanks for being here. Let's see. She was a heavy drinker, so 2 bottles of wine between them wouldn't be that much. By her admission, she did drink, but she doesn't like to be drunk. And unless it's like on the weekend or something, which this happened on the weekend. But the neighbors seemed to indicate that they thought that she was drunk and there were lots of fights happening at that home. Let's see. We might be more efficient on trials in the UK, but sentences are far too lenient here. Part of the problem with leniency, Vivian, is that the jails fill up very quickly and prisons fill up, and there becomes a point where you're looking at the justice system and the number of convicted defendants, or I guess in that case they're convicts, and you're saying either we need to build more jails or we need to let somebody out of jail. And when the jail becomes a revolving door where one person comes in and somebody has to go out, then you start, you've got the corrections, you've got, the appellate courts saying, feeling pressure, saying, hey, we don't want to let this guy out, but there is no room. We have nowhere to put him. And at that point, you're starting to see people that come in and the judge might say, hey, we've got somebody who's guilty here, but we're just going to put him on probation. And say, as long as you're good, you don't go to jail because we don't have room to house you. It becomes an interesting scenario. Let's see. Just got a super chat I'm reading, or not a super chat, a text really quickly. Tammy, thank you very much for that text. I appreciate that. I'm not going to read it on the air, obviously. You sent it on the chat for a reason. But thank you for the kind words. George had a black eye and bumps on his head, and a baseball bat was taken as evidence. Cassie, yes, and the fact that Sarah brought up the baseball bat, I think it was. It wasn't that she was just bringing up, oh, and by the way, there's going to be a baseball bat in the house, and that's because my son likes baseball. She brought it up because she was there and saw it being taken as evidence. And so she at that point, she's like, oh, and by the way, that's my son's baseball bat, because he likes baseball. The baseball bat was taken and possibly could be used in the commission of this crime. The medical examiner seemed to say, according to the police officers, and they could be lying here because police officers can lie in an interrogation, seemed to say that the injuries that George sustained weren't from being in the suitcase. They weren't caused by the suitcase bumping up against the suitcase or something like that. And I think for sure the scratches on his back, that would make sense, because for a scratch to happen, he would have to be rotating or twisting in the suitcase with the outside of the suitcase not moving with him. And by what we saw, first of all, yes, he was big enough to fit in the suitcase, but not big enough to sit in the suitcase and spin and roll and stretch and things like that. So the scratches definitely would not be part of that. And she has an account for why those are there anyway. So a guy gets drunk and decides to play hide and seek in a trunk and only have another blitz drunk to rescue him. That's pretty much suicide. I do think that the George being drunk definitely was a factor in him getting into the suitcase. Whether it was she put him there because he had passed out, or that she convinced him to go there because he didn't have his wits about him and he thought they was able to convince him that it might be funny. Okay. Alcohol blackout is a real thing. The conscience shuts down, but the body keeps going. It's scary. But it's not a defense in Florida. You can't say, I was drunk, I didn't know what I was doing, so I shouldn't be convicted. Definite hungover. That's why she wanted the drink, the Pepsi. Jamie C. says, I have 2.5 months to get a yellow courthouse. Seems like forever. It'll go fast. We have some great trials coming up, Jamie. It's going to be great. Sharon Ken Sharp, welcome. You are late, but you're here. Negligent homicide, definitely not a murder, first degree, in my opinion. The problem is, let's pull this up really quickly. Let's go where we are in Florida, right? Do a quick Google here. Okay. The problem with charging her for first-degree murder in George's death is that, according to Florida statute 782.041A, first-degree murder occurs when someone commits a premeditated murder or felony murder upon another human being. The premeditated is going to be the catch, because now the police would have to prove that she had thought this out and planned this. And although she may have, and we suspect that may be the case, and that this was all just an idea, this was the game, and she was getting him drunk for that reason, we can suspect that. Where's the evidence that the prosecutor can present to the jury? Where's the Google search that says, how to get someone drunk enough to lock them in a suitcase, or how long does it take for someone to die in a suitcase? Where's that beforehand? Where's that evidence that will show that she was thinking about this for a while, that she was planning this? And that's going to be the difficulty. So I think they charged correctly on this one at second degree, even though it could have been first degree murder. As far as if we knew what Sarah knew, it could have been first degree murder possibly, but we need to have that evidence to support it. All right, I'm a Dr. Pepper. If you're a Dr. Pepper, we're a Dr. Pepper too. All right, it's going to be an Oscar winner film. It's going to be an Oscar winner film. Tilted Tiara, no chatting today. I'm at work. Welcome, Tilted Tiara. Have a great day at work. Love the surprise video. Fun last night. We all needed a laugh at the end of the day. Thank you. When does this trial start? Catherine, this trial, meaning the Thomas Randolph trial that we're waiting for, is in jury selection right now, and we don't know how many have been selected, or even if any have been selected. The initial screening process might be very lengthy. Might be a ton of questions that they're asking, and because we don't have cameras on in the courtroom during the jury selection, we're sort of in the dark right now. But it's expected to start either this week or at the latest, I'd say Monday, because the attorney said 3 days of jury selection. Judge thought 1. It definitely was not 1. We're on day 2 here. Let's see. Yeah, it's Thursday, so it was Wednesday, Thursday. So it could be tomorrow before a jury's seated. How far before the crime does pre-med have to be? Kathy, this is something that was brought up a little bit in when we're talking about intentional, right? You planned it out. The court and the law basically says it only has to exist for a moment. It only has to be there for a little bit for there to be intent. Premeditation probably has to be a little bit more than that. Let's do a quick comparison. Okay. So premeditation requires that the defendant planned the murder before it was committed or was lying in wait for the victim. So premeditation exists allegedly in this case with Thomas Randolph, where he seems to have hired a hitman and gone through all these steps to get everything ready and put the scenario into place and how she's going to go in first and he's going to be waiting for her and then he was going to shoot the hitman, which he did. That looks premeditated, whereas Sarah Boone's case, it could have been a spur of the moment or in the moment thing, and that would be the difference. It only needs to be a second. That's for the intention, Red Pen, to have it be intentional. And in her mind, the second she said, George is in the suitcase, I can hear him yelling my name, I'm tired of hearing him, I'm going to go upstairs. That is intentional. That leaving him in the suitcase is intentional, with him saying, I can't breathe. She's leaving him to die. That's what the prosecution's saying. Can you imagine how Randolph would be during jury selection? He'll want his way all day. Hopefully he's not trying to talk. That could be bad. Rudy says, just got my AC back on. Woohoo! That's a recipe for means cold weather coming soon, if the AC is working. Holly says premeditation can happen in a split second. Intentional can happen in a split second. I think you have to plan it out. You've got to think it through. So it might be a little longer than that. I guess in the moment it would be a crime of passion for second degree. For it to be a crime of passion, I think something else would have to be there. There would have to be she found him cheating on her, or walks in and he's with somebody else, or she discovers in the moment that happened. There has to be some other element to make it a crime of passion instead of just like, I love this person and I killed them. I heard it only takes a few minutes to die in a suitcase. She called X much later. Was he already dead? Yes. When she called the X, she had already gone down and checked on George, and George was not alive. Holly, I'm in Texas, and pre-med includes last-minute planning. It's possible the whole hiding in a suitcase idea may have been hers. Yeah, as long as it was planned out, as long as she basically put the pieces together and said, I can do this, and it will result in this, and then do it. It could be very brief, but it has to be planned out. Had they done suitcase plane before? Kelly, she says no. She would never put George in a suitcase, and no, this has never happened before. But there's been some allegations made that she put her son in a suitcase at some time, and I don't know the situation around that. I'll have to look and research what that is, if that was her saying that something, they were playing a fun game or what, but that seems to stick in my mind a little bit. She did say that he cheated on her. I still don't think it would make it a crime of passion with her saying, everything is good, everything is fine. Per Cornell Law School, premeditation, when an individual contemplates for any length of time undertaking an activity and then subsequently takes the action. So, yeah, you've got to think it out, but it doesn't have to. This doesn't mean like weeks of research and study, but you've got to put all the pieces together in your head. You're building the puzzle mentally before you build it physically, right? She's all about building puzzles and games, but for it to be premeditation, she would have had to have thought this through and said, I can do this. I'll put him in the suitcase. I can zip him up. He won't be able to get out. And I could get rid of him that way. Can I Google this for you? I will definitely Google this for you. And we're talking about Florida's. We're talking about Florida's statute, right? Let's see. This is section 782.07. Let's see. So we've got manslaughter. So negligent homicide or manslaughter is a maximum prison sentence of 15 years and a fine of up to $10,000. But manslaughter is aggravated manslaughter of an elderly person or disabled adult. Let's see. The killing of a human being by the act, procurement, and culpable negligence of another without lawful justification according to the provisions of Chapter 776, and in cases in which such killing shall not be excusable homicide or murder, like self-defense, according to the provisions of this chapter, is manslaughter, a felony of the second degree, punishable as in provided sections. So there you'd have the act, procurement, or culpable negligence without justification. True Crime Junkie, welcome. Love this group. Thank you for making the workdays seem better. True Crime, we need to get you a new job. If workdays are not fun for you, we've got to find you a job that is fun. Because I tell you, life is good when you love what you do for work. If there's a movie she shouldn't have any income off, it should go to his family. Okay, so this gets into the Son of Sam laws, Eva, where you've got the court trying to step in and saying, because you committed this crime, you should not benefit financially. And those stood for a long time, but they're being whittled away and eroding. And it's basically saying, hey, just because you're convicted doesn't mean you've lost your freedom of speech. You've got this right to say what you want. We can't tell you that you can't make money from saying what you want. So those are slowly going away, and we're seeing more and more that the people who are in jail can make money off of it. And the only thing that we can do to slow that down is to order them to compensate, to pay this restitution for the injured parties. At least that way they get some money. Might be amazing to know that a ton of crimes are committed under the influence, so I don't know how that's a defense. I worked in a parole probation offense and assisted with PSI reports. Yes, drugs, anything that changes the way you're able to think, to make decisions, your decision-making process, generally is not a good thing. I mean, it's not like getting drunk makes you smarter or smoking weed makes you smarter. You might think so in the moment, but really it ends up making poor decisions for most people. Yay, can chat with my friends today. 7 of the greatest months of my life with y'all. Thank you, Lil Miss. Good to have you here. Thank you so much. Love the yellow courthouse by your name. Looks good. So many yellow courthouses. Okay. Let's see. Jennifer, we need to type the exclamation point before gifts. So just exclamation point gifts, and that'll work on that command. I need a dictionary. Here we go. I will Google this for you. We're using the Florida's definitions, by the way. It's always hard when there's a B in the word. Let's see. Squirrel. The Florida Supreme Court defined culpable negligence as conduct showing reckless disregard for human life and for the safety of other persons, or conduct showing entire lack of care, which raises a presumption of indifference to the consequences. So culpable means that you're accountable, or you can be held responsible for it. So culpable negligence would be that you didn't do something that you probably should have done, and because of that, there was an outcome, and that there's a reasonable belief that, say, like culpable negligence would come into play when your action or conduct isn't illegal. It's not like you're firing a firearm at somebody or attacking someone, but it's causing, or it's in disregard for that human life or the safety of other people. Then when it does happen, then you can be charged with that. Jenny says, I wish I had a job I loved. We need to start a job board of only good jobs. Mayla's mom gifted a membership. Thank you very much. That went to Vicky Huser. Vicky Huser, thank you so much, and congratulations. Mayla's mom, thank you. Was Boone read already? We did read Boone already last night as well. but a little more, I guess, respectfully this morning. Let's see, 260 miles visiting patients today. Thanks, all right. That is a long drive. I hope you get compensated by the mile. And I'm not sure what the going rate is. I think for tax purposes, there's like a set rate. When I drove a lot of miles, I drove like, I don't know, 3,000 miles in a month. They were paying me like 33.5 cents a mile. Is that what the same rate is? If they can convince a jury that Sarah Boone knew that he was trouble, yet continued to leave him there and maybe even push the case down the stairs, etc., then it's more than culpable negligence to me. They're just going for second-degree murder. They're not going for manslaughter in this one. But I think they're going to be able to convince the jury that she caused his injuries. Rudy Patootie gifted 1 membership as well. That went to Jenny G.A. Congratulations, Jenny. You're back in green. Thank you, Rudy. Can I please get the definition of culpable negligence about 183.638X, just like the Parkland trial? Okay, Sarah, hang on 1 second. I'm not sure what you're asking here. This is Florida. We're dealing, and Parkland was out of Florida as well. Oh, are you talking about the? Sarah, you're talking about the officer on scene, right? I was thinking the original Parkland shooting, which was pled guilty. I think the difference is in that case, he was able to articulate that what he was doing, he thought he was right. That he was doing what was protecting people. And even though what he was doing may not have been the best thing to do, by having that as a defense, saying, here's my mindset, this is what I was thinking. This wasn't me saying, I don't care, people are getting injured, I'm not going to do anything about it. This was him saying, in my mind, this is the best thing I could do to help protect these students. Even though it was a poor decision process that led him to that decision, I think that's why we didn't see a conviction in that one. Be Kind number 1 says just gifted 5 memberships as well. Wow. Let's see. Those went to, let's see if I can find them. Toxic Orchid, congratulations. Crusoe, Duck and Felonies. I had to be careful there. Sissy Zyke and Kelly Earl, congratulations all. Thank you, Be Kind number 1 as well. Be Kind is being kind. I'm late. Do we know if the new trial will start today? Janice, we don't know for sure if it will start until we have a jury seated, and we don't have a jury yet. We do know that nothing will happen in Clark County, Nevada, in that courthouse until noon, because that's when they start. That's 9 o'clock their time. They're 3 hours behind me. So we won't know anything really until then, and we could be waiting on one more juror. And we could be that close, and it could also be that they haven't sat any jurors yet. Remember, there were cases where we've heard that the jury pool comes in and they said, hey, have any of you heard of this trial? And everybody raised their hand. And, that's a problem. So if they're in that situation, that we might be in for a long haul on seating a jury. My husband drove oversized loads, and he put over 1 million miles on a big truck. Okay, 1 million miles on a big truck. First of all, that's a milestone for every truck driver to hit. That's awesome, especially if you can do it safely. But if he's doing 1 million miles of oversized loads, that is huge. That is huge, because oversized loads, Carolyn, other people might not. There are all sorts of restrictions. You can't just drive a truck and put a flag on it and say oversize and just drive as if you would normally. You've got flaggers, you've got pilot vehicles that maybe, you might have to literally have power companies lifting power lines and rerouting you around low bridges. You can only transport stuff during certain hours during the day and possibly even during off-peak hours during traffic in some areas. It's a major undertaking to drive oversized loads. I used to sell metal roof and wall panels, for metal buildings, and we'd sell panels that were 140 feet long. And so we'd have this huge stretch shredder. We literally had to tear the fence down around our building so that one of the trucks could pull out and make the turn. But that was just the least of their worries getting out of the parking lot. Okay, let's see. Toxic says, "Oh my goodness, I'm yellow. Thank you to whoever gifted me that lovely membership. This is your yellow, your 6 months there, or I think is it 6 or 7? I'm not sure. Toxic. It's one of the two, but you are in yellow again. Let's see. Somebody said there's a kidnapping. Mary Murphy. There's a kidnapping murder trial going on right now. Just started. Iowa versus Henry Dickens." Yeah, that's the content on that one. I think we're going to pass for this one. We're going to skip on that trial. Let's see. They did expect opening statements today, according to Court TV yesterday. We expected one day, and we're keeping an eye on this. It may happen. So let me check and see if we've got any updates yet. Slowly. I'm not seeing anything yet on this one. We don't have anything yet. We're still waiting for the jury, so they might expect it, but until it happens, we just don't know. Love you. Have fun. All right, are you going to grab a mailer? You can grab a mailer? Okay, awesome. Mrs. R.A. is headed out with the kids for their fun adventure. That one, trials with kids as victims are just difficult. They're difficult. The content, first of all, oftentimes will cause problems for YouTube or for me on YouTube. It's rough for the community as well. It's not that I can't do it. I definitely could. It's just not something we like to do as a community. One time I was an oversized load because I had a big dinner a few days ago. It says 80s Music Man. I got the flagger treatment, caution lights, everything. Oh man, it sounds like a great dinner. I'll tell you, I once took a client out to dinner, and he brought a couple of his crew because I was selling these metal panels, and this was actually in Vegas. Took him out to dinner, and they chose some restaurant, and all I know is there was like a golden cow on the sign outside, and the restaurant is so dimly lit that I'm like tripping over tables. I'm like, they could be serving me anything, and I wouldn't know. But it's dimly lit, and we had steaks, and they were good. They were like really good. And then for dessert, they brought out this. I mean, there was this tray, and the guy's doing all sorts of stuff. And there's ice cream. I'm like, oh, cool, ice cream. And then he lights the thing on fire. It's like whoosh, and it was just like lit up the whole restaurant. I was picking up the bill for that trip, and I think there were 4, me and 4 people. And I think we paid $900 something. So I guess it wasn't too bad, but it was a little spendy. Thanks, Mary. I appreciate your understanding on that one. Did they get a jury for the widower trial? We're still waiting, Tiffany. Hopefully noon we'll know if it's going to happen today. It could still be this afternoon that we start opening statements. How do you decide which chats to answer? Well, I click. Mostly I scan ahead, I read like half the chat. So if you want me to read something that's highly inappropriate, put it at the second half of your chat, because I only read the first part and I'm like, hey, that sounds interesting. I try to scroll through and follow as much as I can. Court TV now says they expect opening statements tomorrow, so they must still be selecting a jury. I did not watch the Michael Barsoni trial. Did go insane. I was told to, but I just haven't had time to watch. I played chat roulette. No, that's different. That's different. $900 for dinner. Excuse me. Purple Haze. I say it's okay. I never in my life, other than when I'm out, when I was working that job, and it was a job, that bill did not come out of my wallet. It went on my card, and the company reimburses me because I was whining and dining some of our clients. But never in my life have I paid anything close to that for any meal. The only reason I paid for that is because, I was getting reimbursed. Is there a podcast tomorrow? Yes, there is. There is. And I've already got a police video that we want to watch. All Dogs Go to Heaven. It's a good one. It's a good one. You're going to love it. It's short. It's 30 seconds long, but it's a great one. Eileen, love this chat. Welcome. It's a fantastic group you're a part of. Let's see. All right, we could do a little court hopping if we're waiting, but honestly, it's looking like we're going to have hopefully opening statements tomorrow. It will probably go into the first witnesses as well. Britta just gifted a membership. It went to Parrot Court. Congratulations, Parrot Court. Thank you, Britta. You guys are great. Oh, she has a lavender purse. We have to go check out Judge Boyd if she has a lavender purse. Just one second. Oh, is this it's still that trial though, right? CG, it's that one that we don't want to cover.
Since he's he was using it before, but since that he hasn't used it. That's what he tells me.
Well, we can't get a UA because he stuck his hand in the cup. Nobody does that. I don't know anybody who would purposely or accidentally stick their hand in a cup of urine.
There was no urine, ma'am. I just grabbed the cup. I didn't even.
Yeah, nobody does that. You wasted a UA in this court. So, counsel, anything you wish to say on behalf of your client?
Judge, I would say that he's 55. I think his report, he's got child support obligations. He looks, I don't know that he's not diagnosed as mental slowness, but he seems to be. And he's he's not had real good jobs right now. He works at a cook, but he is employed.
Did you hear that?
He's been employed, and
Judge, he's not diagnosed with mental slowness, but he seems to be.
Will really make much difference or correct his behaviors. I would ask you to make him do outpatient treatment. Let's see if give him a chance. I mean, I agree with you. I think it's kind of ridiculous what he says, but give him outpatient.
I would tell you, counsel, outpatient treatment is going to be out of the question. He's going into custody today. So either he's going to prison or either he's going to treatment. Those are his choices. Either he's going to safety. I know they're recommending SADC, but for someone to purposely invalidate a test, that tells me a little bit where he is with regards to his sobriety. So either you have a choice. You can go to safety or you can go to prison. If you wish to go to prison, I will sentence you to 4 years. Which do you choose, prison or treatment?
I'll take treatment.
Yeah.
All right. The court will sentence you to 8 years in the prison. Thank you. Suspended and probated for 8 years. Take in consideration 2023 CR 0888. Thank you. Got to sentence you to Safe P, followed by aftercare. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be the UA hotline upon release. There's to be no unsupervised contact with minors. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months, And if everything is going well with the field visits, probation, I'm going to want random field visits after that, and you'll be able to pick how often you wish to do that. There's to be 200 hours of community service restitution. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Judge, you got anything else?
Anything else you need from the court to be successful?
So he had either 4 years in
All
prison.
right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right. You do have a right to appeal since there were issues raised through pretrial motions. But however, this is a felony conviction. You're not allowed to own or possess any weapons or ammunition, any body armor or anything of that nature. Do you understand? If you have a question over what a weapon or ammunition is or body armor, you'll need to speak to an attorney. Do you understand?
Why did I not know that felons can't
Mr.
possess
Wahlberg,
body armor?
Here's the thing. When I ask for people to do UAs, sometimes I know that people are going to come in and they're going to be positive. I can see the signs when people are going to be positive. The reason why I'm asking is because I'm trying to determine, one, your level of truthfulness, and two, where you are in your sobriety. And when you are dishonest with me about your sobriety, you know what that tells me? That tells me you need to be in somebody's inpatient treatment. So you're going to inpatient treatment because of you. All you had to do was take the UA instead of sabotaging the UA test. You understand?
Yes, ma'am.
All right. Good luck to you.
Thank you, Judge.
You're welcome. I don't know if that's.
Apparently, you can't stick your hand in the cup.
Can I see the parties? Where'd they go? It was David McClain. I guess they're looking into something. All right. Yeah, when you get a chance. Miguel Rangel.
So she takes breaks during a trial to handle other business.
Okay.
Don't shake his hand.
All right. So are you the attorney on all these cases or just one?
Just one, Your Honor, I believe.
Who is the attorney on the other cases?
I believe Mr. Castañon was appointed on this, Judge, on these cases. There seemed to be, sorry, Judge, something got a little convoluted with the jail when I made the bonds for Mr. Rangel.
Ah. All right, Mr. Rangel, you understand that he was the bondsman, not to be your attorney? All right. Are you going to have any objection to his withdrawing?
No, Your Honor.
Okay.
He's the bondsman. It's like, Judge, I'm not an attorney. Or I'm not his attorney. I'm just a bondsman.
All right. Thank you.
Thank you, Judge.
All right.
Excused.
Yes. And Mr. Rangel, you're actually set to be back in court on August 15th. Okay. All right. You have any questions about anything of the process?
No, Your Honor.
All right. We'll have you brought back on August 15th.
Attorney's,
All right. Thank
attorney's
you.
beating it to the door. He's
Norma,
like,
can
out
you
of here.
make sure
Good
that
luck.
the other attorney is on
Oh, he did shake his
his
hand.
case? That's 2023 CR 5021. So he'll make sure he has an attorney for that. Okay.
It sounds like whatever he did with the cup, he did it intentionally. Like it was an intentional invalidation.
Michaela Johnson.
Judge, I'm present.
Good morning, Your Honor.
Good morning.
Judge, this is Michaela Johnson.
Good morning. All right. So we're here for discovery. Where are we on discovery?
Judge, I think we're in good shape. We're just going to confer on an offer and would ask for another pretrial.
All right. So has an offer been tendered?
No, Your Honor.
Is that going to be tendered today? Or is that possible to have it tendered today or no?
It's possible.
All right. If it's not, just let me know.
I'm not sure if he wants to give an offer.
All right. So this is what we're going to do. Miss Ferguson.
Yes, ma'am.
On Michaela Johnson, I need a 30-day reset. At that time, I'm going to need an acknowledgement of discovery and an offer to be tendered. And then after that, I'll give you a plea deadline date.
Thank you. Judge, additionally, we
Oh,
have,
just 1 second.
yeah, sure.
One thing at a time, then we'll take up the other thing.
Can do September 14th.
All right.
That's good.
All right. So if you'll get the reset form ready for that. And let me just write this in the phone.
Nisi, I hope you had a great defense, like that they were actually flowers and you were growing them as part of a religious expression of, free speech. Going to court for overgrown weeds. That's awful. I mean, now
right.
I can't look at you the same.
Then in two of the cause numbers,
if this were a crime, I would be locked up
motion
right
to
now
modify
because of my
conditions of
yard.
bond.
I had our little
both
trimmer
parties had a chance to review
ran out
those?
of string and I couldn't weed it. I had like foot tall weeds because that's how fast they grow in about a
We're
week.
not opposed to it if that is verified. Mr. Hancock was just sending me an email. I have not received it yet. It's verifying that she is enrolled in high school. And an alternative campus.
Okay, so here's what we need to do. We need to take that
Judge,
purse.
I certainly can show Mr. Garahan, we do have verification.
Let's see if I can get a screenshot of it.
She is 17 years old, lives in the Northeast School District, Roosevelt High School. Through her mother and planning for her senior year, they have sent her to some alternatives campus for Roosevelt High School. So we're just seeking relief from the monitor so she can get up at, I think.
Judge doesn't give relief from monitors. She doesn't do that.
4 p.m. And Judge, if there's more cause numbers, I would like that to apply to all of them. You made a good point. I filed.
All right. You also have the cause number ending in 3850.
Did you add that, Your Honor, to one of the?
Yes.
Thank you so much.
All right. We're going to go on the record. Court is calling 2023 CR 3848, 3849, and 3850, State of Texas versus Michaela Johnson. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Pat Hancock for Miss Johnson.
And are you Miss Johnson?
Yes, ma'am.
All right. The court is in receipt of motions to alter and amend conditions of bond. State, are you ready to proceed?
Yes, Your Honor.
All right. Defense, you may proceed.
Judge, we filed the motion to amend the conditions of bond as Miss Johnson is on full house arrest GPS. Her mother is present today. And she's 17 years old and she attends Roosevelt High School through Northeast Independent School District. Her mother has been informed that due to these arrests, she would be sent to an alternative campus for the immediate future. And we are just asking permission for her to be able to attend school at 7:45 a.m. I think it's released at 4 p.m. So she'd be home thereafter.
All right. State, any objections?
No objections as long as the device remains in place and the curfew is enforced, Your Honor.
All right. So I'll grant the motions in each cause number, but she is allowed to attend school upon verification. So you need to provide verification to her pretrial services officer.
Done, Your Honor. Thank you.
So, Ms. Johnson,
Yes,
here
ma'am.
are the rules. These are your school hours. That does not include any activities that may or may not be happening. If you detour from your school to somewhere else, what's going to end up happening is I'm going to get a report. Your attorney is going to be called in here and you may end up being taken into custody. You understand?
Yes, ma'am.
All right. Any questions from anyone?
No, Your Honor.
All right. Thank you.
Thank you, Your Honor.
She's like, these are the rules. You understand? Thank you. Good luck.
Yes.
Her purse is a
I had a chance to speak with Mr. Bersani.
Bottega Veneta sold out. The price is $700.
They're not able to get it unless they've got a local court order. And everybody he's talked to nurses, he's talked to other investigators. Everybody's telling them they won't do it because there's supposedly some sort of liability issue.
All right. Norma, I'm going to need Jose Maria Cavazos bench warrant back here. All right.
I've got an address, if that'll help the court for the.
Oh, if you'll give it to Ms. Ferguson.
I can do that, Judge. Thank you.
And Norma, how long do you think it will take to bring him back from El Paso? All right, let's reset this for 30 days, but if he's back here sooner, just let the court know. What date, Ms. Ferguson? All right, so we'll be back on September 14th or maybe earlier. You're welcome.
So why am I shopping for purses right now? This is why I've never carried. Well, I've carried my wife's purse, and that's it. But here I am looking at purses online. Oh man, $700. Rarely does my wife's purse have that much money in it, let alone cost that much. But my wife is not a big purse person. She doesn't like carrying around a whole ton of stuff with her. Okay, I just looked at some of these prices. This company that makes the purse.
Let's hear on Jeffrey Kesey.
$700 is cheap. They have $4,500
Yes.
purses. Wow. Let's go ahead and block this site. Don't need anyone doing any shopping there. Very pricey brand, apparently, because I'm the man.
Court is calling 2022 CR 3040, State of Texas versus Jeffrey Kesey. Could I have parties announced for the record for the state?
Thanks for State of Texas.
Defense.
Your Honor, T. Christopher Lewis on behalf of Jeffrey Peasley.
All right, the court is in possession of a motion to modify conditions of community supervision. Defense is asking that the no unsupervised contact be lifted. Is that correct?
That's correct, Your Honor.
All right, state, do you have any objections?
Yes, because of the nature of the charge, it's a jack like that.
All right, Mr. Kesey, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Who all lives in the home with you?
Now it's my children, my wife, and our former nanny.
All right. So why can't the former nanny, the wife, supervise? Yes.
My former nanny is moving out.
Okay.
And find her own place. And my kids got accepted to a science and technology school outside our district. And it's close 7 miles from my job. It's about 35 miles from my wife's job. So I'll just drop them off, pick them up in school.
Your Honor, I might add,
I was on
during
there this
the
morning.
sentencing process, you indicated that you did not want, at that time, his wife to supervise. You wanted the in-laws who were living with him to supervise and not just the wife. So that's why she couldn't do it.
All right. State, do you have any objection to the wife supervising?
If it is the wife supervising, no, the state has no objection to that, no.
All right. The wife can supervise, but the no unsupervised contact is to remain. All right.
Thank you, Judge.
All right. Yes.
I do want to point out that Mr.
Okay.
That for CPS and
Thank you, probation.
Thank
All right. So this is what we're going to do, because I know school is starting. I want to see how this goes with all of the confusion and miscommunications that sometimes happen when children are in school. So if you'll come back in November, because that will give you September and October to see how people are handling different issues, then the court will reconsider. But for now, the court will allow the wife to supervise.
Thank you, Judge.
And what did you learn from parenting classes?
I learned a lot. I learned different and better choice making when it comes to my children. And I've learned how to take time to react instead of being just immediate reacting from my frustration. And I learned just how to be a better and a more involved father
And I'm sorry, what is your wife's name?
Shyla Kasi,
Spell that.
Shylah.
Parrot Court. These purses cost more than my live view. I mean, I'm not poking fun at anyone who spends that much
All
money
right,
on
is
a
there
purse.
anything else?
Nothing further, Your Honor.
All right, thank you so
Some
much.
of those same people would look at me and say, "You spent how much on a little piece of electronics?" That you know, we just all have our preference there. But I imagine I could spend an equal amount of money on technology.
All right, who's here on Arthur Beecham? Yes.
Thanks for the
All
catch,
right,
Holly.
so it appears that Mr. Beecham is not going to regain competency.
No, Your Honor, that's what the evaluation came back with.
he's dressed
After
for
that
court.
evaluation was done, Judge, the state, and by the state I mean Miss Sally Ungerfer, requested that my client do a DID evaluation through ACOG. We had that evaluation on July 12th. The doctor has 30 days to turn it in. It's just shy of that. I confirmed with the clerks at the magistrate court that they still have not received the results of the DID evaluation. And until we get that back, the prosecutor that I'm conferring with will not kind of have an answer on how to resolve this case, Judge.
All right. So, Mr. Beecham, usually this is the way it works when there are competency issues and persons are not regaining competency. According to the law, you will sort of be on probation for whatever the range of punishment is for your offense. So this offense is 20 years. So unless somebody decides to dismiss your case, that means we're going to be with each other for 20 years. Well, I probably won't be here for another 20 years because I'm in the twilight of my life, but somebody will be here. So this is what we will do. We will just do check-ins. So are you able to come down to the court every now and again?
Yes, ma'am.
All right. So what we'll do is we'll just set him for a check-in. What do you think is appropriate, counsel?
Judge, if whatever the court feels, if you would allow 60 days, Judge.
Okay. Is his mom here?
Yes, Judge.
All right. Could his mom come up, please?
You see Judge Boyd on the Supreme Court. Hopefully she'd televise everything. Oh, Gail Pett, I was starting to write the
Hello.
poll. I did get
All
sidetracked.
right. So I know you work.
Yes, ma'am.
So are you able to Zoom?
Yes, ma'am.
And will you be able to Zoom with him?
Yes, ma'am.
All right. So let's do this. And I'm going to be dependent on you because I'm trying to do what's right to help him. And the state is trying to do what's right. And his counsel is trying to do what's right. So I'm going to schedule you all sort of like what they would do if you were in Judge Carruthers Court, which is the mental health court. It would be nice if I could transfer this file to them. So every 90 days, we're going to have a Zoom meeting. If you feel that he's off his meds or something's going wrong, let us know. Because what I can tell you is when people are off their meds, things quickly go downhill. And then the problem becomes a bigger problem than what it otherwise would have been. So we're going to set him every 90 days to check in, to make sure he's doing okay. And mom, if he's not doing okay, if you will let his attorney know, and attorney, if you'll let me know. And again, if he's off his meds, my intention, and I'm sure the state's intention, is to make sure he gets back on his meds and everything is okay. So, Ms. Ferguson, on this case, can I have a 90-day reset? Oh, you guys will be here on my birthday by Zoom. Okay. People don't care about my birthday. They're just setting things on my birthday. That's okay.
When's her birthday?
All right. Yeah, it's, you know, I walk in the land of the living in the land of the dead since this is the Day of the Dead. All right. So we're going to come back on November 2nd, and you all are writing on the docket sheet that they can appear by Zoom. And council, just make sure that you get the Zoom link
Okay, we have a poll for the
beforehand
GOTY.
so they can have it.
Yes, Your Honor, and just so the court's aware, my client's on a shot for he's on an injection, so
Okay.
he's been consistent with meds.
All
The
right.
entire time.
All right. And Mr. Beecham, is there anything you need from the court?
Well, I was asking if I could get off the monitor.
I tell you what, let's take that up in November because I need a sort of track record to see how you're doing. But I'll still let you do things while you're on the monitor, okay?
Yes, ma'am.
All right. So let me just see where we are and then we'll think about it, okay? All right. Thank you so much. And look at him coming in here with the Notre Dame thing, not realizing I'm an LSU Tiger. All right. I'll see you all back on November 2nd by Zoom. All right.
That's interesting
Thank you. You're welcome.
Because she knows that's not appropriate court attire, but his situation where he's been deemed not competent to stand trial, there might be some mental issues there. She didn't jump all over him and say, hey, you need to be dressed appropriately. And she's like, oh, that's funny that you wear that. That's not even my team, right? But yes, whatever this outcome of the jury poll
Kevin Luna?
is, Ms. Zari can veto it. I don't know what the crime was, but it's got 20 years of probation if he's not fit to stand trial.
All right. So we're here for discovery. And the last time we were here was in June. DNA issues.
Yes, Your Honor.
So where are we?
We are, I just spoke with Mr. Powers. The buccal swab and everything was obtained on July 3rd and then sent to the lab by July 10th. I just reached out to the lab.
Dissociative identity disorder.
3 to 4 weeks for that to come back, which I
Used
was
to be
happy
called like
hear that it came
multiple
back
personalities
pretty quickly.
or
And then I think at that point, then all the discovery, it seems, would be attained. There's some
of
other
that
little
same
victims
nature.
in here that the court may or may not be aware. There might be a co-defendant that might be charged also. I spoke with Mr. Powers about that also. So plea negotiations probably beginning here in the next, this next setting.
All right. So
Possible.
I'm going to give you all a reset for 60 days. And then if you want to come back before then, Mr. Powers, you can set it before then. If you have your information before then, you can come back before then. Because I know DNA evidence, sometimes it's a little iffy. The lab thinks something's going to be done at a certain time, then it's not. So I'll set you for 60 days. And then if your attorney gets information before then and he wants to come back sooner, he can always set it. Okay?
Yes, ma'am.
All right, Ms. Ferguson, on this case, if I can have a 60-day reset, it's Luna. All right, so we'll be back on October 12th.
Hey, Skywriting.
Mr. Luna, do you have any questions?
I can foot the
No,
bill
Your
for this
Honor.
one. That's
Okay.
fine. Don't worry about that.
Yes, discovery. All right, if there's nothing else, you are excused. And everyone, we're taking our recess at exactly 12 because we have a jury coming back.
The jury's made a decision.
Andrew Guerrero.
Good morning, Judge.
All right. And counsel, are you all ready to proceed?
Yes, Judge, we are.
Court is calling 2021 CR 6159, State of Texas versus Andrew David Guerrero. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Alfonso Cabañas for the defendant, Andrew Guerrero.
And are you Andrew David Guerrero?
Yes, ma'am.
I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Andrew David Guerrero who's placed on community supervision in 2021 CR 6159 for the offense of evading arrest, detention with a vehicle on November 19, 2021 for a term of 3 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4. In Bexar County, Texas, the defendant, Andrew David Guerrero, did then and there fail to report to the supervision officer as directed for the months of February and March 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am. And Your Honor, we'll waive the remaining violated conditions.
Any objections to the waivers?
No objections, Judge.
This is Judge Stephanie Boyd out of Bayer County,
All right,
Texas.
did you understand by pleading true to violation of condition number 4, court will find it true, the court could find it true, grant the motion, sentence you up to 3 years in the prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, there is, Your Honor. And did not deny the motion, extend the individual for 6 months and amend conditions to add state ISF cognitive behavioral track, and also have the probationer be supervised by the gang unit. That is also the recommendation by probation.
All right.
I'm going to end the poll here.
That is the recommendation, Judge, and conferring with my client, he's asking the court to follow a recommendation by the probation office.
All right, General, raise your right hand for me.
Yes, ma'am.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Andrew David Guerrero.
All right, so why are you not reporting?
I don't have no excuse, but it was just around COVID and I was having hard times, and that's it.
I have no excuse, but here's my excuse.
2022? That's COVID time?
Yes.
We were having court in 2022, were we not?
Yes.
The lawyer's silent.
And this plea was taken. Yeah, I don't understand.
I was just having a hard time, and I'm just.
All right, so why are you throwing, people are always throwing COVID around.
Well, no, because I was looking for a job. I couldn't find a job. I was just having a hard time.
But what does that have to do about picking up the phone and calling probation?
Well, I had COVID at that time, and I was reporting, but my probation officer had stopped me from going in, and I was just calling, and that's it. And I just stopped.
Here's the thing.
Yes, ma'am.
You can't be before me and being dishonest, because I tell you what I will do. I'll have probation zoom in and let me know what's going on. I know COVID doesn't travel through the phone lines, and they're saying you did not report. That's a problem. So basically what you're telling me is that you had COVID for the months of February and March.
No.
So why are you being dishonest with me?
I'm not. I just
making up reasons for not doing what you're supposed to do. Here's the thing. And this is what I've discovered in my time on the planet. When you do something wrong, you know what the best route is? Usually, I'm not going to get into legal discussions, but usually the best route is, I was wrong, I'm sorry. And guess what? When you say I was wrong, I'm sorry, the other person on the other end, if they don't accept your apology, then that's on them. But you've done all you can do. You can't go back in the past and mess with the time continuum and report. So why were you not reporting?
Just having a hard time, man. I'm sorry. I was just having a hard time.
All right.
I didn't have places to stay. I didn't have a job. I was just having a hard time.
And what's with the drug issue? Do you have drug issues?
No, I don't.
Mm-hmm. All right. Anything else from either side?
Not from defense, Your Honor.
I'll deny the motion.
Yeah, don't mess with the time continuum. Nothing good can come from that.
I'm going to extend you for 6 months. State ISF, cognitive, and gang supervision. All previous conditions remain, and that means the no contact with Brianna Castillo. Is there anything else?
No, yeah, that's fine, but I don't see how she's coming up if that was
just stop talking.
Because that's part of your conditions. No contact with Brianna Castillo.
Uh-oh.
Oh, okay. Well, yes, ma'am.
Yeah.
All right. Is there anything else you need from the court to be successful?
No.
All right. And then probation. Upon release, I'm going to want GPS, and he's allowed to work So it'll be partial for work. And that'll be until further notice. Is there anything else you need from the court?
No, ma'am, thank you.
All right, good luck to you.
Thank you, Judge.
You're welcome.
His lawyer was trying to muzzle him. Like, no, shut up. You already made it worse for you than it should have been. All he needed to say was sorry and say, I don't have an excuse. I'm sorry.
I'm sorry, Austin Anderson. Austin Anderson. All right, your attorney's not here. Just give me a moment. Leslie Cox. All right, counsel, we're here today for discovery. It's driving while intoxicated.
It is, Judge. So, Judge, we were here, last time we were here, I need to get a discovery order on file, the blood discovery. I checked on that this morning, found the order was in, the submission was in drafts on my e-file. We didn't get it in, and that's on me, Judge.
Okay.
And so if we could.
So do you have a copy with you today or no?
We're e-filed it, and I can bring you the copy for you to sign.
All right. So that needs to be done today.
Yes, ma'am.
Ms. Ferguson, if I can have a 30-day reset on Cox for discovery.
These ones are all in the courtroom with the judge. This is in person, but she does Zoom.
All right, just sign the reset form, then you're excused.
She's using Zoom as a, I mean, it's convenient because sometimes she'll have like probation Zoom in and join the meeting, but really this is right in front of her. They're appearing right in front of her. There's no purpose for her to be on Zoom other than that's an easy way for her to be on YouTube, which she likes being.
Oh, thank you.
Hang on, I don't know who this is. 1 second.
You give me the. Yes, please. Alexander Castro.
Hello.
Those are the ones that.
All right, State, did you tender an offer?
Yes, Your Honor. We did today.
All right. All right, Ms. Ferguson. On Alexander Castro, I need a plea deadline date in 2 weeks. All right, August 24th is going to be your plea deadline date. On that date, you need to let the court know whether or not you're accepting the state's offer. After that, the court will not consider any plea bargain agreements without good cause. Otherwise, you have the plea open to the court. Do you understand?
Yeah.
He
All
dressed
right,
well for
once you
court.
sign your reset form, you're excused.
Maybe excuse when we sign.
Yes.
Thank you.
He dressed really well. Dr. Jennifer, we are waiting for the jury to be selected. They actually are going to continue the process in the Thomas Randolph case. In about 45 minutes, they'll start continuing to select a jury.
Austin Anderson.
We anticipate possibly opening
Is the
statements
attorney here for
tomorrow.
Austin Anderson? Okay. Thank you. Matthew Castro. All right. All right. You all are asking for bond?
Yes, Your Honor. He has 6 cases. 2 of them where he's been remanded without bond. The original bond on each was $5,000, and I believe the district attorney has agreed to $7,500 on each. So we're
What are his
apparently he was remanded
charges?
without bond on July the 29th.
I can give you.
I'm sorry, June 29th.
I can give you some history, Judge. So on the 2 state jails that he's remanded without, Mr. Butler was appointed. He's also appointed on an unauthorized use for a motor vehicle, which must be a different bondsman because Mr. Castro still shows as being on bond for those or for that case. The bondsman filed an affidavit of surety to surrender, which of course was signed by the court. That's what triggered the remand without bond. while he was in fugitive status. He's alleged to have committed some new offenses. I got offended on those. He does have a bond set on those, but the issue is he's still remanded without on Mr. Butler's 2 cases.
All right. So normally the court will proceed, but because he's picked up new cases, you all need to file motions and we need to have a hearing. So if you all file a motion and if the state has no objection, the court can hear it on Monday.
I'll be on vacation on Monday.
Okay. If you want to appear by Zoom, you can, or if you
I'll be on
want
an airplane.
Okay. So whatever date you all want to set it on. Okay. All right. Or
I'd
if
like
you
your
all
lawyer
want to file a
check in
motion
from
and we'll
first
hear
class
it
on vacation.
this afternoon during break.
Not sure I have time to do that.
Okay. All right. Just let the court know then when would you all, well, these are all night mag and CM numbers. So just set it with Ms. Ferguson when you all want to bring it back and the court will hear it.
Thank you.
Okay. You're welcome. Or maybe Judge Nahara will hear it without a motion, but I need a motion. Yes. I mean, he may hear it without a motion, but I need a motion.
Okay.
Okay.
Holly, now you cannot unsee the purse. The purse will be the first thing you see every time you see Stephanie Boyd's live stream.
Yvette Martinez. Yvette Martinez. Oh, you're here? Just have a seat.
Sure, and just to let you know, the victim on that is here for looking at.
Okay, we are. Where's Kenneth Longacre? All right, thank you.
So that is like a $7,000 purse. Is that what we're saying?
I do have confidence in you.
That is so spendy. Man, yeah, I can see why she keeps it right on camera, where she makes sure nobody steals it.
There's nobody on Zoom yet. No, you can just send them the ID. No, they shouldn't.
Good morning, Marcy. Somebody put the brand name of the bag, the purse in chat earlier. I went to the website and was browsing, and then I looked at the prices, and I immediately deleted the website from my browsing history. I don't want Mrs. R.A. to see it. Not that she would ever buy it, but to think that I was actually willing to, to spend that much money on a purse. She'll have words with me. Bottega, I think that's it. Or Bottega. I think it's Bottega. She has many, many purses. Like I don't think I've ever seen the same purse twice. I did close the goatee poll. I was surprised by the numbers. Keeping it trimmed was the slight winner over, and then shave it off was second place. ZZ Top did not do well, so I'm not going to be. This won't be a full length beard anytime soon. Sure what she's doing. Hippie chick, I mean, if you've got the money and you like that sort of thing, I can see doing it. I know some people do invest in purses. I didn't know they actually increased in value, but I guess they can. I mean, I've spent a lot more than that on my electronic equipment. So, but I look at that as an investment because it does earn me money. But yeah, that's a ton. That's a ton for a purse. It's more like 4,500 to 5,000. Still a lot. See, Loomis says, I was watching chat the other day and a member from Kansas or with Kansas and the name was upset because they were having problems with their son and nobody responded. I had phone issues, so I couldn't. I missed it as well, Lil Miss. I don't remember who that was. I didn't see that.
Judge, we're trying to remember what the order was for the trial tomorrow or today. Are we doing arguments at 11 or 1 o'clock?
No, you're doing arguments on Friday.
Oh, no. I mean, for the hearing that we had yesterday.
Oh, 11.
11, okay, yeah. I did. So,
So that's the jury trial she's talking about. We're not going to be following that one. I would rather have the money in the purse than spend it on a purse, says Paula Mack. There's a little funny saying that I heard growing up that I heard from another fisherman that said, my worst fear in life is that when I die, hang on, that when I die, my wife sells my fishing gear for what I told her I spent on it. So maybe that's the same thing with purses. Let's see. Any news or updates on BA from his brother or anyone else? I think we're all itching to see where it goes. Watching from Japan. You talking about Zachariah Ederson? ZA? And welcome. Good. Thanks for checking in from Japan, Aaron. Appreciate that. My phone's ringing, and I'm the only one here. It's going to be my son's friend, and he calls like 500 times. Hang on one second. The phone isn't there. I can hear it ringing, but it's not here. All right, the judge is on a break. I think we're going to go on a break too. What happened to the Black Widow retrial is openings tomorrow. Denny Don, we think they will be. Court starts in about half an hour, but they're still in jury selection.
Yes.
So we need them to finish selecting a jury before they can do opening statements.
It's an MTR. It's very early. It was called to my client yesterday. The thing is, he got for adjudication on June 3rd, 2022. He got into ICE custody in June 4th, the next day, 2022, and then sentenced 18 months in federal jail. And he just
He's still in federal custody?
No, he just got deported in May, and have 4 kids here, U.S. citizens. He came back to work to support them. They stopped him for speeding in Fort Worth on July 27.
Okay.
And we just talked to the ADA to see if he could continue him. And she agreed with some GPS restrictions. And we think we could put it for tomorrow in the dockets to do it.
Is he going to be here?
What?
Is he going? He's not.
He's in Burke County Jail, and he's not here today, Judge.
Oh.
We will try.
Can't be here.
Well, I will tell you, I'm not inclined to continue him because he wasn't supposed to come back.
Judge, I just went round and round.
Yeah, we were talking about the last 30 minutes.
I mean,
And so I said the only way, I'd be okay with it is if there's GPS so we can find him. If he's not gonna, I don't know.
Yeah, Judge, the only thing is I talked to him yesterday. He came back because of the need to support his children. He have
No, I mean,
4 of them, 18, 15, 12.
I understand. I'll keep an open mind and hear everybody's argument, but.
And actually, I might amend it to make a condition that he's deported, he needs to stay.
No, the problem is I've already put that as a condition. So I tell you what, I will keep an open mind.
Thank you, Judge.
And that's all I can say.
Thank you, Judge.
And we'll see what happens.
Okay, Aaron, let me answer
Can we
that.
set it, if you think you can set it for tomorrow, Judge? In the morning?
Tomorrow is going to be dicey because we have a closing arguments tomorrow, but maybe Monday. Is that too late or you want to do it sooner?
I mean, I
I mean, if you want to talk to
Just
Ms.
want it someday
Ferguson
other than today.
and see,
Okay,
yeah,
we're gonna
just go ahead,
transition
tell
away
her,
from
put
this.
it on Friday and we'll see what we can do. Sure.
I appreciate it.
All right, you'll just have to wait though between the trial and everything. Okay.
I'd be patient as always. I like to be.
Oh, I know you will. I appreciate you, Miguel.
All right. Let me tell you. Let me answer this question first, Aaron. Sorry for making you waiting. In the ZA case, the last I heard is that it's a long delay. Basically, they've filed notice of appeal, but I think they have to get the official court transcript, which is like 6 months out before they can do anything, and they get one shot at this appeal, so they have to do everything all at once. So it's not something they want to rush, even though it's from Zachary Anderson's position, he's not guilty. He's sitting in prison, convicted of something he says he didn't do. So he wants to get a redo and get a fair shot at a trial or have a different outcome. But you don't want to shoot before you're ready, right? They want to put everything together in that package because they get one shot. They're going to say, here are all the reasons why why we should have an appeal, and make sure it's perfect. So they need the transcript first, which takes a long time to get, and then they're going to work on it. It could actually be a year, 2, 3 years before an appeal gets heard. So we'll see that play out. So no updates yet. Did you see that Nicholas Cruz's cousin was arrested for threatening to shoot? Oh my goodness. Is it run in the family? That is crazy. I did not see that. Okay. All right. I think we're going to be done for now, and we're going to go ahead and take a break. I'll be watching. If for some reason they seat a jury and they're ready to start, we're going to let everyone know, and we'll go live with the opening statements of the Thomas Randolph trial, which I'm so excited. It's going to be such a fun case. I don't know why that's recording, but don't need that. Anyway, I think I hit the button earlier. How long has that been red, guys? How long was that button red? Probably about half an hour or so. Anyway, let's go ahead and wrap it up. We will maybe have something later today. We definitely have a podcast tomorrow. Can you port us to Brandy? I would love to port you to Brandy. She did that the other day for me, and that was wonderful. So give me just 1 second. Don't go anywhere, guys. We'll get the portal set up to Brandy. She is live. Looks like she's doing the Georgia versus Austin Ford best friend murder retrial. So we'll save that. Just know that don't leave. It's fun if we all go there at the same time. So you have to wait till you go till the very end of the show. So once I turn off the logo and stop the live stream, then it will transfer us all. That's when the portal opens and we all jump in, and boom, we're at Brandy's, and it's fun. We just all show up at once instead of filtering in. Anyway, I will say, when we go to Brandy's, please, the first thing to do, and you might have to remind each other, is to click the like button, and then just let her know how happy we are that she's feeling better. So thank you very much. Tonight, when you go home, please hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again, which might be this afternoon if court happens, if they can get a jury seated. Otherwise, it'll probably be tomorrow with opening statements in the Thomas Randolph case. Thank you, everyone. Thank you for our wonderful mods. Hope you guys are having a fantastic day, and it continues over there on Brandy's channel. Keep the notifications set up for me, because we might, fingers crossed, we might still be live later today with opening statements if they get done in time. Anyway, thanks. That's about it. Have a great one today. We'll see you. Bye. Okay, we're portaling now.